Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. My name is Riffat Hussain and I'm your host for the next hour. As our viewers are aware, the free legal advice show gives you the opportunity to call the programme with your legal problems and receive an answer from me. I can deal with a wide variety of topics related to English law, as that is the jurisdiction I practice in. You may contact the studio live on the landline number you find at the bottom of the screen. Alternatively, if you wish not to ring in live but still wish to send through a question, then you will find a mobile number to which you can send a message on WhatsApp. Feel free to contact me with any queries that you have, and I will try and get through as many as I am able to do so this evening. I have already received a number of queries through WhatsApp, so I will go directly to those. The first query that I have relates to an individual who has arrived in the United Kingdom on a spouse visa. Unfortunately, this marriage has now broken down, and I'm told that the marriage has broken down due to domestic violence. The individual asks, what are their options and how can they best proceed? As this person entered the United Kingdom with a spouse visa, then there are a number of options that are available to you. There is a route under the immigration rules which provides for status in the United Kingdom if a marriage breaks down due to domestic violence. Domestic violence has a wide definition and is not restricted, as is the common belief, to physical violence. Domestic violence can entail things like psychological abuse, emotional abuse, financial abuse, forced domestic servitude. So there is a whole host of behaviours, or there are a whole host of behaviours which come within that definition of domestic violence. Domestic violence is also a category under immigration law which retains, unusually retains, the right to legal aid funding. As we know, legal aid funding has been curtailed for most categories over the last decade and more. And so you are advised to seek independent legal advice, as the evidential requirements for such an application can be quite onerous, and it's important that the application is prepared properly to evidence that the marriage has in fact broken down due to domestic violence and is not purely based on your account of domestic violence taking place. An individual who is successful in making such an application would usually be granted indefinite leave to remain, hence why the threshold can be quite high in terms of evidencing the domestic violence. That can be done through a number of means, and there are plenty of organisations out there that can help you, both in supporting you after the marriage breaks down, both practically and emotionally, but also assisting in providing legal advice and accessing the various other legal remedies, such as injunctions, for you. There is another aspect to these applications. As many of you will know, a spouse application usually comes with a condition of no recourse to public funds. That means that the individual who is in the United Kingdom on a spouse visa has no right to access any benefits or to receive public services apart from NHS and medical services. And therefore, the person who has come to the United Kingdom is left quite vulnerable. There is an associated application known as a concession, which would allow you to access benefits and so seek advice in respect of that also. We do have a caller on the line, so I will move on to taking the call. Hello, assalamu alaikum. Assalamu alaikum. Hello, assalamu alaikum. You are live on air. Assalamu alaikum. I'm sorry, we seem to be having problems hearing our caller. Hello, assalamu alaikum. You are live on air.
Hello, assalamu alaikum. Thanks very much, first of all, for your information. Okay, my question is regarding the social housing. I just explain you in within 5 to 10 seconds.
Yes, brother.
Okay, what happened? Nearly 7 years I've been living in a one-bedroom house with the 4 children and my missus. Recently, because I'm on 10 years route, the family route, you know.
Yes.
Recently, I've been given access to Republic Fund, and I did apply in Reading Borough Council. But I'm feeling they are little bit. They're moving me with my family to a temporary accommodation.
Yes.
But I'm feeling they are a little bit reluctant to give me social housing or council house. I don't know. I'm really stuck. I don't know what to do, and where they are moving is quite far from the school. My 4 of children they are going, so it's really, very big headache for me and for my children. So I don't really know what to do, how to deal with them, how to ask them.
Sure.
If you can give me any advice.
Sure.
Please.
And brother, how old are your children?
Okay, my youngest child, he's 9, and the oldest, he's 16. He just started his college, and where we live is close by Reading College.
And when you say they're moving you away, far away, how far away from college and school will they move you?
It's nearly, it's nearly 2 miles away now.
Okay. Thank you, brother. Thank you for your question, and I will answer that if you continue to watch. The difficulty with social housing is, as we know, that there is limited stock. That the demand most certainly outstrips supply, and so councils find themselves often in a very, very difficult position. That there just isn't the housing needed to accommodate everybody. You have recourse to public funds. You also have children, and you're in a one-bedroom property, which clearly is not suitable for an entire family. You have gone in the right step in terms of getting your access to public funds, and that should alleviate some of the difficulties. But you may need to think more practically about your position. If the housing stock is not available in Reading, you may want to look at renting privately and applying for housing benefit, for instance, and that may assist you, rather than waiting for the local council to find a property which probably doesn't exist and may not exist for a long period of time. So look at alternatives. Usually the best course of action with these types of inquiries is to speak to your local Citizens Advice Bureau. They will have local knowledge of the area. They will be able to communicate with your local council. You may want to speak to your local councillor. Again, they may be able to help with that situation, but look at other options that may be available to you. Should you believe that the council are treating you unfairly in some way, you may want to pursue a complaint, but I would certainly suggest that you look at the other options first. Seek the advice from the Citizens Advice Bureau, speak to your local councillor and see if some other solution can be made available for you that resolves this without having to go through a complaints process. However, if you are still dissatisfied, then a formal complaints process will exist. Request a copy of that and pursue that. If you are still dissatisfied, then there is a local authority ombudsman who can also look at the complaint independently, but you do need to first follow the complaints process through. I hope that does answer your question, and thank you. I move on to I will actually go back to the question I was answering before our brother called with his question, and that was specifically about the domestic violence concession. The domestic violence concession is extremely important. It's not a period of leave in itself. It's a bridge between the spouse visa and the application to be made under the domestic violence provisions. However, the key feature is that it does allow the applicant access to public funds for a period of 3 years, which allows a victim of domestic violence to escape their predicament, to escape the marital home if that's where the domestic violence is taking place, and to receive support and sanctuary elsewhere whilst the application is being prepared. Usually that application is not does not benefit from legal aid funding. Most firms, however, will complete that on a pro bono free basis for you. So once again, seek legal advice in respect of that. I move on to another question that I've received through WhatsApp, and this is in relation to an employer not paying minimum wages. Minimum wage is a legal requirement, or living wage as it's now more commonly known as. You should have been provided terms of employment, and the terms should clearly stipulate your remuneration and the terms of that employment. But if you do feel that you are not being paid correctly, then the first port of call would be to speak to your employer. They may not realise they're not paying you accurately, and then to follow any internal grievance process. If again that continues, then you may wish to seek some further legal advice in respect of your employment rights and how to exercise those. The best place to look at as well for further guidance in respect of any kind of employer dispute, be that minimum salary or any other terms, is the ACAS, that's the ACAS website. It's a reconciliation service which can also help you speak to your employer, but there's also very useful resources on the website that you can consult in respect of your rights and how to exercise those as well, because it is a delicate situation and it may be resolved quite easily by taking the correct channel through that way. We are going to take a short break. Following the break, I will continue to take your calls. Please feel free to call the landline to speak to me live on air. Alternatively, send your messages through to WhatsApp, and I will speak to you on the other side of this break. Thank you. Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I am your host Riffat Hussain, and we continue with this process of you asking your legal questions and me providing you with the answers. As I said before we went into the break, that you can contact me in two ways, either by ringing the telephone number on the bottom of your screen and speaking to me live on the show. Alternatively, if you prefer not to speak to me on the show but would still wish to submit your question, then you can do so through WhatsApp, and you will find the mobile number also at the bottom of your screen. I move on to another question I have received through WhatsApp, and that relates to British citizenship. The viewer asks, I came to the UK as a student in 2014. In 2018, I married a British citizen. Can I apply for citizenship? So the question it relates to an individual who has been in the United Kingdom now for some 6 years. But there are details missing to provide a direct answer. But the short answer is it will depend on the circumstances that you find yourself in. The requirements for naturalisation as a British citizen, which is what most adults will apply for, are that you have been resident in the United Kingdom for a period of 5 years with continuous leave. So you must have had valid status. If you came to the UK in 2014 and still had your student visa, or your student visa was still valid in 2018 when you married your British spouse, and varied your leave into that of a spouse of a British citizen, then you continue to reside in the United Kingdom lawfully and would probably meet that requirement. There is, however, a requirement that the last year before the application, so the 12 months preceding the application for naturalisation as a citizen, are a period whereby you are free from immigration restrictions, i.e. you have indefinite leave to remain. Based on the information you have provided, namely that you were here as a student and then applied for to vary your leave or applied for leave as a spouse of a British citizen in 2018, it's highly unlikely that you currently hold indefinite leave to remain, and therefore probably would not be eligible for naturalisation as a British citizen. I hope that answers your question. If it doesn't, please feel free to either send me another question on WhatsApp or to call in live, and I will address that further for you. I have another question, again, another immigration question, similar lines. My wife came to the UK as a Tier 1 partner and then got further leave to remain under the 10-year route for 2.5 years. She has been in the United Kingdom for 6 years now. Does any of the or do any of the past 6 years count towards indefinite leave to remain based on the further leave to remain 5 years route or 10-year long residency route? So with regard to the further leave to remain, the answer would be no. That route would be completed, as in the full route. So the further leave to remain either would need to be completed for the 5 years, if it's granted for 5 years. But as you said, your wife has been granted for 10 years, so she would need to complete the 10 years route as a family member under the route that she's in. However, it is correct that there is another route that you mentioned, which is the 10-year long residence rule. For those purposes, any lawful continuous status in the UK counts towards that period. So if your wife arrived in the United Kingdom and has now completed 6 years, as long as there is not a break in her continuous residence and she has been here for that period of time, then another 4 years would mean that she can make an application under the long residence rules. So I hope that answers your question. Moving on to another question. We have a question again based on British citizenship, a popular topic for this evening. And if you have a question relating to citizenship or your status in the United Kingdom, please feel free to send that through. The questioner asks, in respect of children who were born overseas, young children born overseas to a British citizen by descent. The children are therefore not British, and unfortunately the British father has now passed away. The question is there a way to bring the children to the United Kingdom? The difficulty with British citizen by descent is that it is not automatically passed on to children born overseas. And that would be the difficulty in this particular case. The children are not British. And under normal circumstances, those children would then need to be invited to the United Kingdom under the traditional spouse and family routes that are available under the immigration rules. And the children would eventually naturalise or register as British citizens due to their own circumstances rather than the circumstances of their British parent. Just for our viewers that are not familiar with the different types of citizenship, British citizenship by descent is a form of citizenship whereby the British citizen has acquired their citizenship through another individual who had their citizenship handed down to them. There is a second form of citizenship, which is a citizen without descent, and that, or other than descent, as the terminology is. And that individual, the person who has citizenship other than descent, that citizenship passes automatically. However, the latter and the citizenship in this question, unfortunately, does not. If the British father, unfortunately, has now passed away, then unless there are other categories in which those children would have been able to come to the UK, I'm afraid the answer would be no. They cannot arrive in the UK just because they are children of a British citizen by descent. And I'm sorry, because that's probably not the answer that you were looking for, but that is unfortunately the position that you are in at the moment. In terms of my next question, that relates to not immigration, but an individual who asks, I have received penalty points on my license. Am I under an obligation to notify my employer in respect of those? Again, the answer depends on your contract of employment and the terms of your employment. And it would depend on the nature of your employment. If you are a driver and are required to hold a clean license, there may be terms which require you to notify your employer if your license has penalty points, or there are questions around your driving skills. If you are in a completely unrelated profession, you may be an accountant, for instance, or in some other profession, where driving is not a requirement of your employment, then please do still consult the terms of your employment, but it is unlikely that in those circumstances your employer will need to know about any penalty points. Where the employer may be interested is if your conduct affects your integrity in respect of the job that you undertake, and certain professional bodies would also be interested in you declaring, or would have a requirement for you to declare any penalty points or any issues around conduct and integrity. But certainly consult your terms and conditions. If you are governed by a professional body, then look at the code of conduct and then make a judgment on that basis. Those are the questions I have received through WhatsApp, and I shall see if I have more to go through. I have another question here in relation to, and if you just bear with me a moment, and I'll just read the question and get myself up to speed with that. I have another question briefly in relation to complaining against a GP. I did touch upon this last week as well. Like any professional body, your GP practice will have a formal complaints policy. Initially speak to your GP to air any concerns that you have. If you feel that the issue is beyond that, or the issue is not being resolved, then request a formal complaints policy and follow that through. The policy will notify you exactly what the time limits are and what the process to be followed is. And failing that, if you are still not satisfied, then there is a parliamentary ombudsman, a health ombudsman that you can also complain to. Just be aware that there are deadlines in respect of the Ombudsman Service, and they will not usually look at complaints that are older than 12 months. That's still ample time to have followed through the complaints process by the GP, and most ombudsmen will not look at a complaint where the internal complaints process for a particular practice have not been followed. Again, usually it's with these types of complaints, if you are wanting to complain formally, you may want to speak to your local Citizens Advice Bureau. There are also Health Watch and various organisations who specialise in these types of issues. They may be able to mediate on your behalf or speak to the practice on your behalf, which then will prevent the complaint from escalating and to get you the relevant resolution. But again, the best option is to contact the Citizens Advice, because even if they are not able to help, they will be able to give you a list of organisations that will do and point you in the right direction. I hope that really does answer your question, but if it doesn't, as I say, please feel free to pick up the phone and speak to me live on air, the telephone number you will find at the bottom of your screen. Alternatively, send through your message on WhatsApp, and I will endeavour to pick that up and provide any further details that I may have missed off from there. We will be proceeding shortly to another break. Please continue to watch and send through your questions. I will get through them as quickly as I am able to do so. Continue to watch, and I look forward to seeing you on the other side of this break. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I continue to be your host, Riffat Hussain, and I will continue to answer your questions in respect of any legal issues that you may be experiencing. Please feel free to call me live on air on the telephone number that you see on the bottom of your screen, or alternatively send through your question on WhatsApp and I will endeavour to answer that for you. Now, during the break, I have received some further questions, which I will answer. So the question I've received is, I want to ask about me and my wife regarding UK study, plus a spouse visa. I am currently staying in South Africa and my wife is staying in Pakistan. She is a software engineer. She wants to do masters in the UK. I wanted to know if we apply for a visa together, will we get a visa, or what will be the future after coming to the UK? It's a very, very broad question, and thank you for sending that through. Essentially, it encompasses a wide variety of legal issues. The first one being an immigration matter. The questioner's wife is seeking to come to the UK, and she's wanting to study in the United Kingdom. Now, in terms of students coming to the United Kingdom, they would need to apply under the points-based system for entry into the United Kingdom. There are specific requirements, and the student will need to have had a letter of acceptance from a university or college that they are intending to study at. They will also need to show that they have the relevant financial provision to support themselves alongside any qualification requirements for the course. With regards to family members, then an individual who is here on a Tier 4 student visa is able to apply for any dependents to join them. So that in short is the answer. You would need an approved place on a course with an institution in the United Kingdom before your wife makes the application to enter as a student, having fulfilled the eligibility criteria as a student. She is then able to sponsor you as her dependent, again subject to its own eligibility criteria in terms of finances, relationship and so forth, and would then you would be able to join her in the United Kingdom. I hope that does answer your question, and thank you for sending that through. I have another question, this time relating to passports, and in relation specifically to British passports. And this is a common concern that we have seen in recent times. The concern being that individuals who renewed their passports early, their previous British passports early, essentially had that time added on to the new passport. So, for instance, an individual may have renewed 6 months early, and the passport office in the United Kingdom would have then issued a passport for 10 years plus the 6 months remaining from the previous passport. The problem with that is that with the changes with Brexit and the regulations that no longer apply to us here, the United Kingdom is no longer able to issue a passport for a period more than 10 years. So even though your passport may say it's valid for another 3, 4, 5, 6, 7 months, if the reality is that your passport was valid for 10.5 years because you renewed early, then unfortunately you do lose those 6 months. We are finding, unfortunately, a number of people booking flights and holidays who are then finding that they are unable to take that holiday. Again, I think this has been widely reported in the news. Quite recently, I read a report of a mother who had to leave her child behind because the passport wasn't valid for the duration it needed to be, again, being caught out by these rules on validity of passports for longer than a period of 10 years or 5 years, as would be the case for a child. So do check your passports, and if you have previously renewed early, then just be aware that it may not be acceptable, and you may still need to renew again to have that period of 6 months, which most countries will require before they issue entry into their country or for you to be permitted to travel. I have another question. This is, Assalamu alaikum. I live in the property which is in my brother's name. It has a £140,000 loan on it. I am paying the mortgage for the last 19 years. Can I have a charge on it and get it transferred to my name? Thank you. So walaikum salam, and thank you for your question. The property, if it's legally registered to your brother, then the ownership of that property lies with your brother. The only way you are able to transfer that property to your own name is with the consent of your brother, if he chooses to either gift that to you or to sell that on an agreement of a reduced price. That is an agreement that you would enter with your brother, and then draw up the formal documentation for that to take place. I don't believe that there is any provision for you to simply transfer the property to your name, simply on the basis that you have been paying for it for the last 19 years. When you paid for that property, you will have known that the property is in your brother's name, and therefore you have no right to the title of that property. So the short answer there, brother, for you is that I don't believe that there is any such provision unless your brother agrees to it. If there is a dispute about payments and what this payment was, then that would probably lie elsewhere. If there is a contract in terms of the loan between you and your brother, or some other kind of agreement in terms of the £140,000 loan on the property, but just by virtue of you paying for it doesn't allow you to transfer title to your name, as far as I'm aware. The next question is, me and my husband have split up, and now he's on bail subject to bail conditions. I want to know, can he still work through national insurance or not, as his visa has expired in May 14, 2021? And also, can I apply for child maintenance? With regards to the question, I understand this to be as follows. The questioner, I believe, is a British citizen or a person settled in the United Kingdom, and the husband is the person that's been sponsored to come to the United Kingdom on a spouse visa. The marriage has broken down and appears to be subject to a criminal investigation, and thus the husband is on bail subject to certain conditions. With regards to the national insurance number question, then if an individual's period of leave has expired in the United Kingdom, then they are no longer permitted to work. The permission to work is hand in hand, or comes hand in hand with the permission to reside and to be present in the United Kingdom. And so if that has expired, the right to work and the permission to work has also expired. So if this individual continues to work, then that would be unlawful and a criminal offence. With regards to child maintenance, then that is a more delicate situation and would need applications to the family court. What you will be advised to do is seek legal advice from a family lawyer with regards to any applications for maintenance that you may seek to make. But as I said, if your husband or your former husband is no longer permitted to work, and if they cease working, then they probably haven't got the funds to pay the child maintenance. On a side note, and it's not in the question, however, an individual who has sponsored a spouse to come to the United Kingdom, and the spouse themselves, in fact, are required to notify the Home Office if there has been a material change in the circumstances. The fact that you have now split up from your husband and no longer residing as husband and wife would constitute a change in circumstances. So you would be required to notify the Home Office that your husband is no longer in a relationship with you and no longer residing with you also. I hope that answers your question, and thank you for sending that through. So that's the questions that I have received through WhatsApp. If you do have any questions that you would like me to answer, please feel free to send your question through on WhatsApp. The mobile number is on the bottom right of your screen. Alternatively, if you wish to speak to me live on air, then there is a landline number that you can call and come through and speak to me directly. If I have answered a question for you this evening, but you feel that I've not addressed the issue or I've misunderstood your question, then also please feel free to either send through a follow-up question or to ring me live on air, and I will address that for you. I do have some more questions coming through, which I will move on to. The next question, if I could just take a moment to familiarise myself with that. So I have a question in relation to, unfortunately, again, a marriage that appears to have broken down. The question is a rather lengthy one. So what I will do is I will just read through that to digest the information. We will now go to a short break. Upon my return from that break, I will then read through this question with you and provide the answer to that question. Please continue to watch, and I will see you on the other side of this break. Thank you. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. Just before we went into the break, I had a question that had come through on WhatsApp. Before I deal with that question, however, I believe we have a caller on the line, so I will take this question first. Hello, Assalamu alaikum.
Hello, Assalamu alaikum. My question is, I've been granted 10 years old as a parent.
Yes.
And my extension is due soon. And my question is, as a single parent, my question is, which form do I need to fill up?
So 10 years route as a parent.
Yes.
And is this your first extension? So have you just completed the first 2.5 years?
Second one.
The second, so this will be a completion of 5 years.
Yeah, I've been completed 5 years. It's going to be 7.5 years. Yeah.
That's and in terms of the circumstances of your application, you still have the child upon which the application was based and are still living as a family unit. sorry, is that correct? You are still living with the child?
Yeah, I'm living with the child. Yes,
Thank you.
yes.
Sorry, I didn't hear that. That's okay. Thank you. Thank you for that question. And if you continue to listen, I will answer that for you
And
now.
one more thing. Sorry.
Yes, please.
I've been granted as a for the public fund as well.
Mm-hmm.
Do I need to request again, or is going to be just fill it? Because I've been granted last time.
No,
the
so
public fund.
yes, so the public funds will just continue. The same conditions will continue. When does your current leave expire?
Is the next month.
In next month. Okay.
Yep.
Thank you, brother. Thank you for your
Thank
question. Inshallah, I'll answer that now for you.
Cheers.
Okay, thank you. So our brother asks the question that he is currently on an immigration route, which is a 10-year route to settlement. And this route has been granted, or this leave has been granted to him because he has a family life in the United Kingdom with a child who is either a British citizen or has been here for a long period of time, usually more than 7 years, and therefore is what we call under the immigration rules a qualifying child. The brother is coming up to the second period of renewal. So usually with a 10-year route application, the first period of leave will be 2.5 years, and then another 3 periods of 2.5 years as well. And at each 2.5-year interval, an application must be made to the Home Office before the first period of leave expires in order to extend that period of leave. And our brother asks us which form does he need to complete. The form is an FLR-FP form, but these applications are done online. And so the names of the forms are not as important as they once used to be, as long as you find the right category that you are applying in. And it's much easier to do that now that it's an online application, and complete the online application for that particular category. In your case, family life application, further leave to remain, FLR, family life would be the FP application. Then that will take you to the relevant page. But if you didn't know the name of the application, as long as you put in the FLR, child route or parent route, partner route, then it does still take you to the relevant screen on the Home Office.gov website. Again, be aware to be following the correct website. Sometimes a lot of forms come up, a lot of websites come up if you search through a search engine. So always look for the .gov.uk ending to ensure that it is a secure government website and the correct website that you are applying through. But the short answer was the FLRFP. The second part of your question was, will the public funds entitlement continue? Then yes, if you have already been granted that will continue into this application. And when you are issued with your new biometric residence permit, that will not have the no recourse to public funds endorsement on there. Just on another point, your leave expires, you say, next month. You are entitled to submit the application up to 28 days before the period of before the date of the expiry. Please do not submit the application any sooner than that, because that could then affect the validity of the application in that regard. Although there are some changes and some further case law policy notes in respect of that more recently, but it's still advisable not to submit before the 28 days ahead of your expiry of the application. Also, please don't submit after the expiry of the application, because then the application, you will become an overstayer by the time you submit the application. The reason why the application is submitted before the period of leave expires, so whilst you still have your current leave, is to ensure that you that your current leave conditions continue. Under immigration law, when you have an application or when you have a period of leave and you submit your next application or a valid application for the next period of leave, either in the same category or a different category, then you are under immigration law granted an automatic extension of the leave that you have at that period of time until the Home Office decides your new application. You will often hear this referred to as 3C leave. That refers to the section of the legislation that provides for that, but it means that you continue to benefit from the rights that you had from your first period of leave. Of course, if you wait till your leave expires, the problem then is that you no longer have those rights or that leave, and you must therefore wait for the Home Office to make a decision without lawful residence and also without the permission to work and access to public funds if that's what you had. So it can have quite a detrimental effect. These applications under the family route currently are taking a significant period of time, usually now between 9 to 12 months for a decision to be made. And unfortunately, it seems that these delays are going to get worse rather than better in the foreseeable future. So it's important to ensure you've submitted the correct application, that you have filled in the relevant pages, that the application is signed where it needs to be signed, and that there is nothing within that application that makes it invalid. You will also need to pay the relevant fee online, or if you are applying for a fee waiver, then you need to make that application. A fee waiver, if you are interested, or if anybody is interested, is an application that can be made to the Home Office asking them to waive the requirement to pay a fee and to pay the immigration health surcharge. So, for example, with this application, the Home Office application fee is £1,033. There's also a requirement to pay the immigration health surcharge, which amounts to approximately £1,560. So in total, you're looking at over £2,500 in terms of application fees. That can be quite difficult for somebody who may be on benefits at the moment, who may be on a low income, particularly around this pandemic and the employment climate that we find ourselves in. If that is a situation you find yourself in, then please do not delay making your application. Check if there is an associated fee waiver application that you are able to make. The fee waiver application is then the application that you would need to make before your leave expires. Do not panic if your fee waiver application has not been determined by the time your leave to remain has expired. So, for example, if an individual's leave expires on the 1st of October and they submit the fee waiver application online today, you get confirmation that the application is submitted, then you are secure in the fact that that application has been submitted, and that the Home Office will usually take around 6 weeks to decide whether or not to grant that fee waiver. The important date then is the date that the fee waiver is either granted or rejected. If the fee waiver is granted, you have 10 working days to then make the application for your leave to remain. You must do that within 10 working days. Your visa is automatically extended up until that point and throughout the period that the fee waiver is under consideration. If the fee waiver is rejected, you will then need to pay the fee and submit your application on the same day, and that will then keep you secure from becoming an overstayer. So those are the provisions in respect of fee waivers and extending your period of leave. But if you do submit a fee waiver, do that whilst your leave is valid, but do not panic if that has not yet been determined at the time that your leave expires. Similar concept in respect of biometric residence. The problem is if you are asked to enroll your biometrics, Alaikum assalam. Right. So in terms of, forgive me, I had a caller coming through, but I believe that call has been dropped. I do apologise for that. So another requirement is in respect of biometric residence. Again, most people panic because they submit the application online, but that there is a requirement to enrol their fingerprints and their biometric detail with the Home Office. The problem with that is, there is no problem with that. You are given a period of time to enrol your biometrics, and if your fingerprints are not enrolled by the time your leave expires but the application has been submitted, then that's not a problem. You will usually be given a date on the application follow-up checklist as to the date by which those biometrics need to be enrolled, and usually the Home Office gives you a period of between 3 to 6 months to do that, but do check the date. But it doesn't have to be done before the leave expires. I hope that answers your question, brother. If I have missed anything, then feel free to give me a call back or to send me a follow-up message on WhatsApp, and I will address that for you. I am now going to conclude this program. Thank you so much for watching today and sending your questions through. Inshallah, I will see you next week. Assalamu alaikum wa rahmatullahi wa barakatuh.